Senator Hunt. Welcome back to the Judiciary Committee. Welcome back.
Thank you. Good afternoon, colleagues. Thank you, Chairman Lathrop and members of the committee. I'm Senator Megan Hunt, MEGANHUNT, and I represent District 8, which includes the neighborhoods of Dundee and Benson in Midtown Omaha. Today I'm presenting LB120. This bill would prohibit employment discrimination based on sexual orientation and gender identity. We have so many people here today and across Nebraska who are passionate about change and equality for our LGBTQ+ residents. An important step of this is to change current law, which allows individuals to be legally denied job opportunities, position appointments, employment training, and position retention based solely on their identity, an identity that has no impact on their ability to perform a job. You may recognize this bill most recently as LB 627, proposed by Senator Patty Pansing-Brooks last session. I wish so much that Senator Pansing-Brooks could be here today, and I want to convey that I know this is an issue that is so close to her heart, and that I know she's watching us from home today, and that she's sending her love to everybody who's here in support of this bill, and everybody who's been so brave to be in support. This bill has made it to the floor several times without success, and while that's disheartening, I'm committed to continuing this fight and for my community. I thank Senator Pansing-Brooks for all the blood, sweat, and tears she's put into this bill, as well as Senator Moorfeld, who introduced it before, Senator Chambers, many people throughout the years who have taken up the mantle of this fight, and I'm very grateful to be among them. I'm also pleased that we were able to approve Senator Pansing-Brooks' LR 466 past August to affirm the Bostock versus Clayton County Supreme Court opinion, which held that an employer who fires an individual for being gay or transgender violates Title VII of the Civil Rights Act. The resolution, while an important step, sent a message by affirming the Supreme Court opinion, and I applaud the work of all the advocates that supported that resolution. However, it's important that we still codify this into state law for a number of reasons. After the Supreme Court ruling Bostock, the Nebraska Equal Opportunity Commission began processing cases on the basis of sexual orientation and gender identity. The commission informed us that while the federal ruling applies, it would be helpful to have this explicitly included in state law so as to make it clear that we are in lockstep with the federal decision. This would also allow them to fully leverage all federal funds available to help protect Nebraskans from discrimination. Clarity in state statute and leveraging funds could also help the NEOC conduct education and outreach efforts. NEOC Director Marta Munn should be here today, and I would let her speak more about this in detail. By passing this into state law, we provide an avenue for recourse, a state or local court instead of a federal court that is more accessible and affordable for plaintiffs. State laws can permit state residents to take action against an employer who has displayed a pattern of discriminatory practices. LB 120 would enable issues to be addressed locally rather than litigating through a federal ruling. It's good governance to update state and local laws to harmonize our laws with changes in federal law to make sure employees and employers don't have to wade through uncertainty and differences among the laws. LB 120 will clarify the law and avoid costly litigation for employers. In countless contexts, when federal law changes due to a court decision, states update their laws to harmonize. It's just a standard good governance practice. Today, approximately 69% of Americans, including the majority of all major religions, support non-discrimination protections for lesbian, gay, bisexual, and transgender individuals. In Nebraska alone, 75% of residents support these protections, including 67% of those in small towns and 82% in medium and large cities, 63% of Protestants, 78% of Catholics. The fact that Nebraska's laws don't reflect the beliefs of our state's citizens or the majority of Americans makes us look closed-minded, and it hurts our ability to attract and retain talent. 22 states in the District of Columbia have already put employment protections in place for their LGBTQ plus citizens, including our own neighboring states of Iowa and Colorado. These protections provide competitive economic advantages to these states because they increase the ability of employers to recruit and retain top talent from across the country. Recently, I conducted an informal survey on social media to which hundreds of Nebraskans responded. I think we're over 1,000 at this point, and I shared those results publicly too. One key takeaway of the survey is that young people don't want to live in a place where the culture doesn't reflect their values. Workers are hesitant to stay or move into a state that doesn't offer protections and security to their positions. Creating a home in a community that doesn't legally appear to be supportive of who you are is very difficult, and it's really hard for me to stand up and say Nebraska is a great place to live and everyone should come live here when I know deep down that we do not have those protections for every Nebraskan. We're competing with our neighboring states for top talent. We're competing with all the other states for top talent, and we cannot afford to be a state that tells young people that they are not welcome here. Whether they were born here, they attend school here, or they're simply looking to make a new life in our great state, we need to make sure that our businesses and our employers have their doors open to everybody. In 1867, our state adopted the wonderful motto, equality before the law. It's time to put that into action and make sure that equality before the law applies to everybody. The way to do this isn't through the subtle recognitions of Pride Month or buying rainbow Oreos or wearing a rainbow t-shirt. It's through legislation and actual legislative action that protects people's right to employment and stable income for their families. I often say that I have the dubious honor of being the first out LGBTQ person ever elected to the Nebraska legislature. And I say it's a dubious honor because I was elected in 2018 and I'm a white cisgender woman, and we have a really long way to go in Nebraska for representation in government that actually reflects the identities of the people we serve. But I'm very proud to be here, and to me it makes no sense that I could be employed and working here in the halls of government where laws are made, and I could have a photo on my desk of my girlfriend or my wife. But if somebody does that at a company in Omaha or a company in Lincoln or a company in Broken Bow, they can be fired for that. To me, that's ethically inconsistent. It's inconsistent with our vision as a state, and we have the power here to change that. And to all my fellow LGBTQ plus Nebraskans, wherever you are in the spectrum and wherever you are in your journey of recognizing your identity and who you are and who you love, I want you to know that you're welcome here and that I will advocate for you, and that there are people here in the legislature and in government who will fight for your right for equal and just laws. So I ask for your support in advancing LB120. This is one of those ideas where people don't really change their mind, right? Like people kind of come into these conversations knowing where they're going to come down. But I think that aligning our state law with federal law, given the Bostock decision, and all the benefits that we know will come from this, it's something that we really ought to finally do. I'd be happy to take any questions.
Okay. Any questions for Senator Hunt?
I do not see any.
Thank you.
Thanks for introducing LB120.
Before we take proponent testimony, I got to ask a couple of questions. How many people, I got to wait for, I'm about to take a poll and I have to be able to see people. Thanks. How many people by show of hands intend to testify in support of this bill? Keep them up. 1, 2, 3, 4, 5, 6, 7, 8. So we have a 3-minute rule and a half hour for proponent testimony. How many of the same people intend to speak on the following bill? Okay, so I'm just going to say this: we'll do 30 minutes of proponents and 30 minutes of opponents. If the proponents of this bill don't have an opportunity to be heard, let's let them be the first ones heard on the next one, if you understand what I mean. How about opponents? How many people are here to be in opposition? That looks like a size of people that we can probably get in, but same thing, you probably, shouldn't assume that, but you may be opposed to the next bill as well, so let's make sure that everybody has a chance today. this afternoon to be heard, given the time limitations that we're under. And with that, we will take the first proponent testifier. Good afternoon, welcome.
Good afternoon, thank you. Chairman Lathrop, members of the Judiciary Committee, I'm Jennifer Krieger with the Greater Omaha Chamber. Today I'm also authorized to appear on behalf of the Lincoln Chamber of Commerce and the Nebraska Chamber, as well as Union Pacific, Cox Communications, and Mutual of Omaha. I'm passing out a letter from the CEO of Union Pacific, Lance Fritz. On behalf of the chambers and all these member companies, we are pleased to support LB120. Our organization's support is based on several factors. We believe passing a law like this is the right thing to do. Employees of companies in Nebraska and job applicants to those firms should have the expectation that they will not be discriminated against by their employer because of who they are, just as they are protected from discrimination based on gender, ethnicity, and religious beliefs. We believe this bill would have tremendous implications for economic development in our state. At our chambers, we work every day with employers that are attempting to recruit employees to their companies. Frequently, they hear direct feedback from talented people who do not want to work in Nebraska because the state does not offer protection from discrimination based on sexual orientation. With an unemployment rate as low as it's ever been, talent recruitment is crucial to building up Nebraska's workforce. Talented employees want to work in an environment that is open, welcome, and non-discriminatory. The state of Nebraska should be such a place. Increasingly, employers consider this issue when they make location decisions that will impact the growth and future opportunities available in our state. It is clear that they believe an inclusive business climate is a competitive business climate. There are some who will argue this bill will create a burden or unnecessary cost on business. That concern is not supported by the facts. Since the city of Omaha passed a similar ordinance in 2012, there have been very few claims or costs to businesses as a result. Also, many companies who operate in Nebraska already have policies aligned with this bill. These companies see talented, hardworking, and engaged employees who love working in a place where they can use their talents fully without fear of lawful discrimination, and they would like to see more. Lastly, and very, very importantly, we would urge the members of the legislature to pass this bill now rather than waiting for another time. In an era where labor is increasingly mobile, we cannot afford to give good people a reason to leave our state or choose another state in which to pursue their careers. We unfortunately have heard from many young Nebraskans who are considering that choice. Nebraska's greatest asset is our people. We would respectfully ask the committee to advance LB120 and allow our state to further grow and benefit all of its people for generations to come. And I realized I forgot to spell my name, Jennifer.
And I knew who you were, so I didn't ask. Thanks, Ms. Krieger. Any questions for this testimony?
Thank you.
Thanks for being here. We appreciate it.
Good afternoon. Welcome.
Good afternoon. Good afternoon, Chairman, Senators. My name is Paige Gotti, spelled P-A-I-G-A-D-E. I currently serve on the Leadership Council of the Lincoln Young Professionals Group and chair of the Public Policy Committee. I'm here to testify on behalf of the Lincoln YPG in support of LB120. We are a group of over 2,000 young business leaders working and living primarily in Lincoln and Lancaster County, Nebraska. Lincoln Young Professional Group's Leadership Council has decided to unanimously support LB120 because we believe it creates a more inclusive and diverse workforce. Diversity and inclusion is outlined very clearly in our public policy areas of interest, and I could argue that this specific issue falls under 3 out of 4 of our areas of focus: economic opportunities, community growth, and social inclusiveness and diversity. This is why we have been supporting this issue at a state and local level for the past 7 years. Fairness and equal treatment are fundamental values of our state. They are essential for a welcoming economy, and perhaps most importantly, they are the basis of our anti-discrimination law. Equality before the law is our state motto and inscribed on the outside of this very building in which we sit today. Equal treatment and fairness are values that the Lincoln Young Professionals Group respects and seeks to promote. We know these are values that hold strong businesses and vibrant communities together. Lincoln YPG stands for the principle that all people should be treated fairly and equally and have their work and merit serve as the basis of reward, not other factors such as race, ethnicity, sexual orientation, or gender identity. Diversity, equity, and inclusion are viewed as a basic expectation, a given, if you will, by the vast majority of young professionals. We believe a welcoming environment in the state of Nebraska is imperative to attracting and retaining young talent. It is an important component of talent acquisition and retention, not just today, but certainly in the future. Many young professionals seek to settle in communities that are aligned with their desire for diversity and inclusion. Business thrives when we have the best talent at our disposal in Nebraska, and this bill serves to protect that talent here in our state. There has never been a good reason not to ban employment discrimination based on sexual orientation and gender identity, and this year is no different. The Supreme Court of the United States ruled last year that federal law bans employment discrimination based on sexual orientation and gender identity, and House of Representatives just passed the Equality Act, which, if signed into law, would extend civil rights protections to prohibit discrimination on the basis of sexual orientation or gender identity. Passing this legislation on the state level is a great opportunity to show that we truly mean what we say when we talk about equality before the law, and to ensure that our citizens are afforded these protections. The time to pass this legislation is now. Lincoln YPG believes that LB120 is an important step in making sure Nebraska remains an attractive and competitive place for business. Our generation looks to retain and attract individuals from diverse backgrounds and with diverse perspectives. We seek out communities that reflect our values, and supporting this bill will allow more people to feel appreciated and protected in their journey to reach their full potential in their work and in their lives. Prohibiting discrimination based on sexual orientation and gender identity is a simple and important step to attracting and retaining talent here in the state of Nebraska. As a state, we should strive to celebrate diversity and be a community that embraces people as their most authentic selves. I urge you to please advance LB120 to general file. It's long overdue. Thank you.
Thank you. There's a question for you, Senator Geist.
Yes, thank you. Thank you for being here. From your perspective and the perspective of the organization that you represent, do you find Lincoln to be an unwelcoming place?
We believe that this is an issue that affects Lincoln and the entire state, and I would echo what Senator Hunt and what the previous testifier said, and that there is an opportunity to show that, to express the welcoming place that we have here in Lincoln.
But, okay, well, maybe across the state. I've just found Nebraska to be very open and welcoming, and I'm curious if that's been your experience.
From my personal experience as a straight white female, I've found it to be very, very welcoming. But we believe that as Gen X and as millennials start to make up an even bigger part of the workforce, that this is an issue that they all feel very passionately about. And as representing the young professionals of Lincoln, that we believe that this is an important issue.
Thank you.
Thank you for your question.
Okay, thank you for being here.
Welcome. Good afternoon.
Good afternoon, members of the Judiciary Committee. My name is Vincent Litwinowitz, VINCENTLITWINOWICZ. I was guessing last night, as I was not having time to prepare for medical reasons the last couple of days, that there was going to be many proponents of LB120 speaking today, presenting many kinds of arguments for its passage this year, finally, in the Nebraska State Legislature. So as a biological male who recently disclosed herself as female on social media right at the turn of 2021, I just want to say that I want to stand up and be counted. Quickly writing this testimony this morning, I just want to say that I'm not harming anyone or breaking any laws. and as a person with a rather severe diagnosed mental illness that has seriously impacted her life, I do not wish nor expect to be discriminated against either based on my gender identity as a female or as a disabled person. It would be so unkind. And from what I understand from the Bible, I believe Jesus would wash my feet just as well as anyone. Should I eventually be able to get a job, for example, as a wheelchair-bound human being with multiple sclerosis, I don't feel that I should be specifically discriminated against in landing a job due to my gender identity, nor do I expect to be discriminated against in any regard due to who I am as a human being. I'm having problem tracking. I am a loving person that is not and will not harm anyone in any situation, nor with regard to any statute. I still have many talents that I really haven't been able to use so far for various reasons that I alluded to, and I want to be able to use them without worry of denial for something so completely irrelevant that I cannot control. And after losing the presidential election, with 74 million people voting for Trump the second time, I hope you Nebraska state senators have the hearts just a little bit in line with the Christian ethic that so many people ascribe to in this state to right the ship just a little bit. On behalf of all of us humans, thank you for listening to our plea, and I wish I could say more. Thank you.
Thank you for being here. I do not see any questions for you today, but we appreciate your testimony.
Thank you.
Good afternoon, welcome back.
Thank you. And let me know if you can't hear me. Good afternoon, Chairperson Lathrop and the rest of the Judiciary Committee. My name is Marna Munn, M-A-R-N-A-M-U-N-N, and I'm an attorney and the Executive Director of the Nebraska Equal Opportunity Commission, or the NEOC. And I'm here to testify in support of LB120. I typically testify in a neutral capacity and did so on the last iteration of this bill, but subsequent to the testimony, as you all know, last summer the U.S. Supreme Court rendered a decision in Bostock versus Clayton County case. The United States Supreme Court recognized that for Title VII of the Civil Rights Act, in employment cases, the protected basis of sex included sexual orientation and gender identity. Since that time, due to the Bostock decision and through our federal work-share agreement with the U.S. Equal Opportunity Commission, or the EEOC, we began to process cases on the basis of sexual orientation and gender identity at the NEOC. The reason for that is that the Nebraska adopted its own version of Title VII called the Nebraska Fair Employment Practices Act, or FEPA. And while it mirrors Title VII and is currently deemed substantially similar to Title VII, sufficient to allow dual filing and coordination of efforts between the NEOC and the EEOC, FEPA is a state law and so is separate and distinct from the federal law. Because of that, changes can be made to the state law that aren't mirrored in the federal law and vice versa. For example, we protect marital status, and we do whistleblower protection, retaliation, and those aren't mirrored in the federal law. And that's fine, because as you all likely remember, just as a refresher, you can always provide greater protections on the state level than you do on the federal level. Troubles arise, however, when the state provides less protections than the federal level. And when that happens, then we become at odds with our federal partner and could fall out of substantial equivalency, would be unable to process dual file cases, lose revenue, and most importantly, Nebraskans would be forced to go to federal agencies located in other states to try to exercise their rights under Title VII because they don't have similar rights under our people law. And I give this refresher because I've been asked numerous times whether, given Bostock and the decision there, whether changing our law would be redundant. And I need to say emphatically it would not be. I don't often talk about our outreach and education mission when I'm here, but that's an enormous part of what we do. We actually try to head off having more investigations by doing more outreach and education. And when the state law doesn't explicitly say what the federal law says, there's lots of inconsistencies. In addition to the fact that the state law can be changed, which creates legal vulnerabilities. So we proceed now under Bostock, but that could be changed, and we have to be honest about that. But in addition to that, when we field over 5,000 technical assistance calls, as well as online inquiries every year, as well as other website visits where we try to provide education and outreach. And when folks try to look up, small businesses in particular, try to look up the law themselves because they cannot afford regular legal counsel and they cannot afford human resources help on a full-time basis, they don't see these words in the law and they think that those are not then protected on the state level, and it almost induces them to break what is now federal law. And so we're in support of the bill this year because of the change on the federal level and how that is better protection, not only for the I'll wrap up quickly, not only for the individuals who identify under these protected bases, but also for the business, the employers in the state to understand and be on the same page with regard to the law. And with that, I'll just take questions if you have them.
Okay. I don't see any questions. I will say this, that we always learn something helpful when you show up, so thanks for being here today.
Thank you. And if anyone has any questions post this hearing, you can always contact me.
Okay. Thank you, Ms. Mott. You can come up.
Good afternoon, Chairman Lathrop. Thank you to you and the committee for allowing me to speak today. My name is Ralph, R-A-L-P-H, last name Kellogg, K-E-L-L-O-G-G. I am coming to you today as a gay man, as someone who has been the subject of discrimination within the workplace, and I want to share a brief part of my story with you. In the mid-2000s, I worked for a financial institution that's no longer in business. It was sold to a larger entity. However, while this institution was in business, I worked there for several years, was given several successive promotions, received numerous corporate accolades and positive performance reviews. One night, my manager called to my home, spoke to my now husband, and the next day I was called into her office under the guise that she wanted to see me the following day. And during that conversation, I was all but berated to tell her who the individual was that answered my home phone. When I finally admitted to her that he was my same-sex partner, now husband, she said, "That's interesting. Thank you for sharing that with me. I'm glad you felt open enough to do so, even though that wasn't what I had gone in to speak to her about." Shortly thereafter, I sort of fell in standing very quickly. I lost subsequent projects, promotions were no longer available to me, and when I went to Human Resources, they said there was nothing that they could do. Ultimately, I went back to my manager and said, "I feel like there's something going on. I feel like it started when I shared with you that I am gay, that I live with a man," and she subsequently said to me, "Well, maybe you're just not a good fit for the organization at this point." What I would share with you is that as someone who works in human resources and someone who listens to people all day long about what they look for in employment, they look for safety, they look for equality, and they look for a place where they can grow and thrive. In an organization, what you're looking for is a place to be safe. no one in no time have I ever run into an LGBTQ person coming into the organization saying they wanted to be treated differently. LGBTQIA people want to be treated fairly without the crux of their identity or their orientation being called into question. I urge you to think about the fact that I am a person sitting here and I am privileged. I'm a white man in a predominantly white man state sitting here in front of you. Imagine those individuals who don't have the opportunity, the black and brown people who live in our state who don't have this opportunity, who face discrimination because of race in addition to orientation or gender identity. Imagine all of those stories that you would hear today. What I'd ask you is to please align the state with what the federal government is doing, embrace the law, and protect your citizens, because we're out here, we matter, and we deserve to be listened to and counted.
Very good. Senator Moorfield.
Thank you for coming today, Mr. Kellogg. So, did that incident happen in Nebraska, or
It did. It did. Yep.
And to kind of bounce off Senator Geist's question, did you feel welcome in the state when that happened to you?
No, absolutely not. What it did was left me fearful of ever disclosing my gender or my sexual orientation in any organization. And to Senator Hunt's comment at the beginning of this session, I never put pictures out on my desk of my spouse. I never talked about my spouse. If you are gay, you get very used to playing the pronoun game at work. So when someone asks you, what did you do over the weekend? You say we, they. You never talk about your spouse. At least I didn't used to. Now I will only seek out and work in organizations where I know that my sexual orientation is secondary or not an issue to the job that I do.
Thank you, Mr. Kellogg. And one other question, and I want to make sure other people get to testify too. I know that in my experience, I've heard of I probably about a dozen Nebraskans who are LGBT that have been had adverse employment action happen or be fired for being gay. Everything from attorneys at top firms here in town all the way down to, I don't want to say down, there's no position that's low, but a whole spectrum of positions. Have you heard of other friends, family members who are LGBT that have had adverse employment action against them here?
Yes, and within the LGBTQIA community, it's a strong network, and I would say that we also know that there are organizations within the state of Nebraska that are not friendly to LGBTQIA people, so we don't even approach them with the opportunity to work or to entertain them as professional options. And imagine the talent that's lost from that simply because of orientation or gender identity. You're going to, turn down the opportunity to bring someone in who's talented in a marketplace where the unemployment is usually half that of the national average.
Thank you very much, Mr. Kellogg.
Thank you.
Senator Geist.
Yes, I want to thank you for your courage. It takes a lot, I'm sure, to come in front of this committee. And in no way would I approve of what you've gone through. I think it's wrong. And so I don't want you to misconstrue my question on a denial of your worth and a denial of me thinking that it's okay for anyone to fire you or discriminate against you because of the choices that you've made, because I don't personally approve of that. I simply wanted to know how welcoming this state is, and I appreciate your testimony.
Thank you.
Mm-hmm.
Okay. Thank you for being here. We appreciate hearing from you.
Thank you very much.
We have time for proponent testimony.
My name is Vicki Wood, V-I-C-K-I-W-O-O-D. Thank you, Senator Lathrop and members of the Judiciary Committee and Senator Hunt for introducing this. I am here today to speak as a proponent of LB120. Last year, I came to speak in favor of a similar bill. I listened as dozens of people gave testimony urging the committee to end the right to discriminate against individuals who identify as LGBTQ+. Then I heard two groups give opposing testimony. Both of them were churches. Somehow, the civil rights of individuals to live free from discrimination is overruled by the religious preferences of a few. I say this as not only disheartening, but an affront to the separation of church and state, which we rely on as part of our constitutional rights. My personal story is actually my son's story. My gay son was fresh out of college and in his first professional job in a small family-owned company in a town close to Lincoln. After a couple of weeks on the job, he noticed that one of the company owners would often make angry and homophobic comments to the office in general. Then a coworker told him that during a car ride to see a client, the company owner spent most of the ride in an angry tirade against gay people and their agenda. My son called me to ask if he could be fired if this business owner discovered that he was gay, and I sadly had to tell him yes. In this state, you can be fired for that. He left the job and took a job in Lincoln, but kept his identity hidden for the first year and was very unsure and nervous about how to answer his coworkers' personal questions. These questions are part of any workplace, especially one that's made up predominantly of young people. This is a discomfort my son has felt his entire life, at school, as a teenager, in college, and now in his adult workplaces. One's sexual orientation has nothing to do with what type of employee they will be, or if they will be a good or bad neighbor. In the 21st century, nobody should fear losing their job or their housing because of who they are or who they love, nor should they live in fear that this could happen to them. Thousands of our LGBTQ+ neighbors, friends, and family know this fear is real and seek protection from this discrimination, which is not a special right, but an equal right. I hope this year that the committee will do the right thing and we won't be back again asking next year. Thank you.
Thank you, Ms. Wood. I do not see any questions, but thanks for being here. Good afternoon.
Hello. Distinguished members of the Judiciary Committee, my name is Lucas Peterson, that's Lucas Peterson, no relation to the Nebraska Attorney General. Please go ahead and call me Luke. I am a resident of the 46th Legislative District here in Lincoln, have been for around 13 years. My testimony represents my personal life experience. I'm not here under any capacity to represent any organization that I may belong to. I come to express my support for Legislative Bill 120 and urge its passage. All Nebraskans deserve an equal opportunity to earn an income in the state, not to be subjected to abject poverty or homelessness due to their honesty. I have lost count how many times I've testified for this piece of legislation. I've come every time it's introduced for this hearing, and I have been ever since I was first fired. You heard that right, first fired for being honest. I was much younger, I was a sophomore in college. University towards the end of the academic year, and it was a very big deal that I joined, apparently, because I had a job at the time. Word had gotten out that I joined the Gay Straight Alliance there, and my employer the next day, or relatively around there, pulled me into his office and told me two things I still have not forgotten. He said, "I find you to be a questionable character, and I don't condone your immoral behavior." After that, he told me to leave, don't show up. I was stunned, speechless, and angry. I couldn't believe this happened, and it still happens today. Passing LB 120 won't let me get my old job back, and trust me, I wouldn't want it, but that gives me peace of mind that I wouldn't ever experience that again if this please pass. Just a couple of points. I imagine that no heterosexual individual looks at equal opportunity employment language. I do. I look at jobs all across that are open, only to be disappointed when I research that they don't have such language. Passing LB 120 would stop that unfair disadvantage. I go through my testimony here, and it says, I talk about how Iowa has had this for a very long time, over 10 years. You can go to Colorado if you were to move there. They have that. Minnesota. People go to Illinois. We're outsourcing our most precious resource here in the state, and that's our people. So, everyone wants to talk about the brain drain. No one does anything about it. This is something. Thank you.
Very good. Thank you for your testimony. We do recognize you as a frequent visitor, and we're glad to have you here today.
Thank you.
Yeah, thanks for coming by. Any other proponents to be heard? We have time for one more. Then we'll go to opponent testimony. Good afternoon.
Good afternoon. It's nice to see you all again. My name is Sarah Rips, SARARIPS. I am the LGBTQIA+ Legal and Policy Counsel for the ACLU of Nebraska. Thank you, Senator Hunt, for bringing this bill, and thank you to the Judiciary Committee for their time today. I'm here in support of LB 120. To all my fellow LGBTQ Nebraskans, I want you to know that the ACLU is committed to fighting for you and your rights. Because honestly, Nebraska should be for everyone. Across the state, there are transgender, gender nonconforming, and non-binary Nebraskans. They are our neighbors, they pay taxes, they raise their families, they serve in our military, and they contribute to our communities. From a policy perspective, LB 120 clearly aligns and is grounded with American values of fairness and equality and freedom. And, of course, ensuring that people who work hard and play by the rules are allowed to move forward in our society. This is a common sense update and revision to our already well-established and strong civil rights laws. Nebraskans do experience discrimination in the workplace based on their gender identity and sexual orientation. We know this based on the testimony you just heard and the legal intakes that the ACLU receives. The Supreme Court's ruling this past summer in Bostock affirmed that discrimination in the workplace based on gender identity and sexual orientation is a violation of Title VII of the Civil Rights Act. Adopting LB 120 would ensure that the laws protecting discrimination in the workplace are in line with federal law and align with the announcements from our own NEOC about how they are rightly applying this decision. Updating our laws provides not only a sense of belonging to more Nebraskans, but it provides clarity to all stakeholders. Approving LB 120 would send a strong, business-friendly message that Nebraska is a state that can attract new businesses, create jobs, address brain drain, and better compete in a global marketplace. That is why the Lincoln, Omaha, and Nebraska Chambers of Commerce have been vocal supporters of this measure and measures like these and should be commended for such. Advancing LB 120 is a good first step to proving why there is no place like Nebraska. Thank you, and I'm happy to address any questions.
I do not see any questions for you, but thanks for being here.
Thank you, Chairman Lathrop.
We will now take up opponent testimony.
DeBoer, and I'm the Executive Director of the Nebraska Catholic Conference, which advocates for the public government coercion and punishment to force individuals, employers, small business owners, nonprofit entities, religious organizations, among others, to affirm conduct and messages that conflict with their sincerely held moral or religious beliefs on marriage and human sexuality. Even former Supreme Court Justice Anthony Kennedy recognized such a view on marriage long has been held and continues to be held in good faith by reasonable and sincere people here and throughout the world. LB120 does not treat those with traditional views on marriage and human sexuality as reasonable and sincere people, but in need of corrective government coercion and punishment. LB120 contains at least several other issues worth briefly noting. First, LB120 undermines the ability of an employer to carry out their business in accord with their mission. For example, it would prohibit a Christian book owner from being able to hire or conduct their business in accord with their faith-based mission. Second, LB120 makes no attempt at adding religious liberty protections. It leaves in place current law protecting the ability of religious organizations to hire on the basis of religion, and current law also offers bona fide occupational qualifications on the basis of sex. LB120, however, fails to address such nuances with respect to the added categories of sexual orientation and gender identity. Third, LB120 undermines concerns for privacy. LB120's reach extends to the terms, conditions, or privileges of employment because of the individual's gender identity. The terms, conditions, and privileges of employment include the use of multi-use locker rooms, restrooms, showers, among other facilities. And LB120 creates legitimate privacy concerns in our public, parochial, and private schools, churches, supermarkets, and restaurants, just to name a few examples. And then fourth, LB120 seeks to not only address statewide employment law, but also addresses local public accommodations law in Section 1. This would inevitably raise serious constitutional issues. In 2019, a three-judge panel of the 8th Circuit Court of Appeals recognized that when such laws seek to regulate speech itself as a public accommodation, it has gone too far, and its interests must give way to the demands of the First Amendment. With that, we would urge your opposition to LB120, and I thank you for your time and consideration and would take any questions.
Okay. I do not see any questions this afternoon, but thanks for being here.
Thank you very much.
Good afternoon, welcome.
Thank you. My name is David Hahn, last name H-A-H-N, Chairman Lathrop and members of the Judiciary Committee. I'm here to oppose LB 120 for the reason that the passage will enable and likely mandate the illiberal policy and practice of forced speech in the workplace, which would violate Nebraska's foundational commitment to pluralism of free speech and free thought. I'm an attorney with admissions to the state, all courts in the state of Nebraska, federal courts as well as state courts, the 8th Circuit Court of Appeals, and the United States Supreme Court. I'm also personally and professionally committed to the importance of free speech as a component of free and diverse thought, and as a part of a healthy political environment. Also, I was an early internet entrepreneur and have been active in the progress and development of internet laws, digital laws, technology company policies and practices. Some of you may remember Governor Jim Exon. I sat with him many hours to help draft the Communications Decency Act, of which you hear so much about. I was on the American Bar Association's Committee on the Law of Commerce and Cyberspace, a founding member of the Internet Committee at the Direct Marketing Association in New York City, and I hold a certificate from the Massachusetts Institute of Technology for technology management. I say that not to preen about my background and so forth, but simply to say that I have a lot of contacts, current and former, with regard to digital companies. I've also been a strong advocate of First Amendment rights. Our company had developed the largest network of colleges and university newspapers in the United States. We spent a considerable amount of time developing special technology for historically black colleges and universities, and we also developed the first school of journalism in Kosovo after the war when free speech was denied. people in Kosovo. In late 2018 and 19 and through 20, as both a lawyer at continuing legal education and also in connection with company representatives, digital technologies, I learned that they were adopting policies that mandated the use of gender-specific or personal pronouns to identify gender identity, and in fact were breaking contracts and hurting people who would not use what is called preferred pronouns, excuse me. You're going to hear from a young man here in Nebraska who built a business and had it lost simply because he would not honestly kneel down to the mandates of a digital company. Now, I'm very close to the policies and practices. I also have talked with key representatives and lawyers who represent large organizations and corporations in Nebraska, and they are intending, without question, to use the Bostock decision and this type of legislation to mandate the use of preferred pronouns for gender identity in the workplace. Thank you for your time, and we'll be happy to answer any questions.
Senator McKinney.
Thank you. Just to clarify, are you saying that your translation of free speech is the right to discriminate based on sexual orientation and gender identity?
No.
Can you clarify then? Because that's what it seemed like.
Well, certainly, anybody that would know me would know that that's certainly not my background, both in my personal and professional life. When I ran for governor in 2006, I had the opportunity to visit with then Senator Barack Obama, and we talked about Nebraska and the importance of language and the use of language in public discourse, and the importance of people being able to express with free speech and free thought views from both sides. And what I see is a trend now, at least in the digital technology world, to enforce language, which is the beginning of thought, as the United States Supreme Court has told us.
So would you say, in your definition of free speech, it would be cool for you to be in a workplace and just say, racist things then?
I'm sorry, I didn't hear the last part of the question.
So would it, in your definition of free speech, would it be okay to just spew racist views all day?
To erase the views?
No, to say racist things in the workplace. Would
No,
that
I
be?
don't think so. I think there certainly is a doctrine of hostile work environment.
So
and language that, by common sense, is known to be demeaning and so forth. That's a common legal principle that, lawyers get together and talk about that. On the other hand, preferred pronouns, to say that you must use a certain pronoun of the many that are advanced by the LGBTQI community, in total disregard of the history of that, of the ideological baggage that language carries, is also a form of discrimination and leads to, in my view, discriminatory practice. It was Justice Kennedy that reminded all of us that at the heart of liberty is the right to define the meaning of existence, the mystery of the universe. And that works for all people. It has to. It can't work for one side of this very important subject. It can't. Or we'll never get there and work through it. And that's my concern, is that in the private workplace, I need to be here and, things are going fine for me. But in the private workplace, people are being hurt because they won't give up their own deeply felt, whether religious or philosophical or sociological viewpoints.
I get that. Just because something is a tradition or you've always done it doesn't always make it right. I just think that there are individuals who currently live in our state that don't feel comfortable in the workplace because employers are discriminating based on their sexual identity and their gender. And we always talk about the good life in Nebraska is a good place for people to live, but how is it a good place if I could be fired if I say I'm gay or express my sexual identity? I just don't.
I agree. Again, if you knew me and my wife and our social life and who we sort of hang out with and how I run my own companies, you would know that I agree with you. On the other hand, I'm also a classical liberal, have been when I was president of the Young Democrats, belonged to the ACLU, litigated cases for people whose right to speak and think was being damaged. So I'm saying that if this law is, well, I know it will be, because I know that there's law firms, I've read legal opinions, that are promoting the notion that if this law is passed without some special notice of the First Amendment rights that need to be protected, they will already start using the law to mandate the use of speech in the workplace. And that hurts other Nebraskans, as you will hear in the next testimony.
Thank you.
Any other questions?
Where in the bill does it mandate that you use certain pronouns? I'm trying to look through here and I'm skimming it, so I'm
sure.
You think it's a consequence of the bill and the protection created in the bill, or is it explicitly require it?
It's not, it doesn't say it in the bill, but with regard to the legal reasoning that would take place, I have seen legal opinions, memos from corporate lawyers of some of the big corporations named here today. Large, mostly digital companies that I know of are already developing plans to require not only the use of certain pronouns, but re-education.
But isn't that the problem in the corporate world? Because the bill doesn't require it, and if Apple or Google or Union Pacific says from now on you're going to use the right pronoun, that's something that's happening at the corporate level and not government requiring it.
Well, yes, except that the legal reasoning, the line of legal reasoning is very clear. They rely on the hostile workplace environment notion, and then coming out of Bostock, and then this specific. I'm not against including non-discrimination.
No, and I'm not accusing you. But I'm just trying to get to the bottom of it.
Yeah, the bottom of it is it will be used, and it's not a. I've been to continuing legal education sessions in Omaha, where partners of large law firms told the audience they will need to start prescribing speech in the workplace, and it will be okay.
Well, okay, I don't know how corporate America is going to respond to this, but I look at this in response to your testimony. Let's say that there are two gay gentlemen that are in the break room. Boss comes through and says, "Come on, ladies, let's get to work." Now, don't you think that's creating a hostile work environment?
It sure could.
So I don't know that I'm buying that, because the flip side of it is there are circumstances where somebody could use that to create a hostile work
Absolutely. There's no question about that, Senator. But there's also no question that this is now moved to the point in terms of legal development past Bostock and with so-called SOBI laws, or the addition of these to non-discrimination laws, that is seen as a legal reason to retrain people how to speak. I mean, the notion of re-education, how to speak, should be scary to every American. It is to me. Requiring it in the workplace.
I think we've been doing that. What about teaching people not to use the N-word? I mean, we've been doing those kinds of things in response to advances we've made in discrimination. And I just have to say, and then I'm done, because I don't want to tie up the afternoon with the debate that you and I could have for a long time, and I would enjoy it. But I don't know that the fact that corporate America may have a response to this is us mandating speech. I agree with you. We dealt with it on, I think, conversion therapy 2 years ago, and on an abortion bill that maybe Senator Albright brought 2 years ago. I understand mandated speech and that we can't do that, but I don't think we're doing that. That may be the reaction of thoughtful people to the consequences of unthoughtful speech.
Maybe. But what I'm here to testify about is this is more than some idea that I thought about. I've witnessed it. I have memos from digital companies. I have memos from really good lawyers in Nebraska, major law firms, indicating that this is the approach they're going to take and telling companies they should do it. So to say that somehow you don't want to deal with it because it's not specifically mandated in the law is really putting your head in the sand. At least this committee should include a statement of purpose that nothing they are doing would require or permit mandated speech, or amend the bill to specifically say that. If that's what you believe, then let's tell people that.
But, well, how is that different than passing a law that says you can't discriminate on the basis of race, and corporate America sending a memo out that says stop using the N-word?
Two different things. A better analogy would be to say if you had a Muslim in the workplace and told them that the word they must use for Allah is Yahweh. Totally different circumstances. Of course, using the N-word is discriminatory and creates a hostile work environment. I don't think anybody of common sense, objects to that. But what I am suggesting is this is not theoretical, okay? And it's not theoretical. I'm not talking about California. I'm talking about Omaha. I'm talking about Lincoln. And this is an issue with which you will have to deal, partially because it's already happened. Your next witness is going to explain how he's lost everything because of this kind of activity. Okay. So I urge you to take some time and make it clear to the state of Nebraska, if this moves forward, that your activity and your votes do not permit the violation of the most fundamental civil right, which is the right of thought and consequently the right of speech. Thank you for your time.
Okay. Thanks, Mr. Hunt.
Hello.
Good afternoon.
Hi. My name is Dirk Konopik, spelled D-I-R-K. Last name Konopik, K-O-N-O-P-I-K. And I'm just going to read pretty much from what I wrote.
That's fine.
Chairman Lathrop and honored senators of Nebraska, good afternoon, and thank you for taking the time to hear my thoughts on LB 120. My name is Dirk Konopik, and I live in the Florence community of Omaha with my wife, 4 young children, and dog. I am a 5th-generation Nebraskan and proudly served in the United States Armed Forces as a nuclear submariner that deployed to the Persian Gulf after 9/11. Service to country is a sacred obligation that I hold dear. I'm also a strong believer in the idea of an American dream, that if you work hard, are honest, and fair, then you can and will be successful. That being said, I greatly appreciate your work on this legislation. I know your work is not easy, and I'm humbled to address you on behalf of my family and company. I drove down from Omaha today to give you firsthand knowledge of what happens when proposed laws and ideas such as those included in LB 120 are implemented as the law of the state, because unfortunately it works to the detriment of Nebraskans like me and my family. In the summer of 2018, my wife and I applied for a coveted business opportunity to work with Amazon as a delivery service partner, or DSP, in their brand new DSP 2.0 program out of Gretna, which was being promoted by Amazon as a path forward for young business people and especially targeted to veterans like myself. From an intense selection process, we were chosen. In fact, our company, Konopik Courier, was the very first operational DSP 2.0 in Nebraska, with operations beginning in October 2018. Like all small business owners and founders, we worked very, very hard. Thankfully, this hard work paid off and we are blessed with success. At the very beginning of our courier recruitment, our company advocated, even so, to Amazon for the hiring of African American rehabilitated felons that showed exceptional promise and motivation. Amazon disagreed with us on that one. We cared and still care about the success of our fellow Nebraskans. Our company consistently reached the highest possible delivery performance rating based on Amazon's self-created metrics. We had a team of over 35 professional couriers, and we're growing. In the fall of 2019, various mid-level management people from Amazon called and wanted to know if we discriminated against transgender people, which we do not and never have. Convoy Courier was always open to hiring anyone who, one, were interested in working hard, and two, desired to become an excellent courier. I even shared a story with this Amazon staffer about a positive hiring experience between myself and a staff member that self-identified to us as transgender, and we made no discriminatory decision against this person and actually hired them and promoted them based on performance. Suddenly, after a year of very strenuous work to grow our business, Amazon ordered us that we would have to take retraining to use transgender words and pronouns and to re-educate our entire staff. Otherwise, Amazon would cut us off immediately. I replied that we had never discriminated, had always worked hard to be thoughtful and courteous to all of our employees. That didn't matter. Amazon specifically said it would be mandatory for us to use transgender preferred pronouns regardless of our faith and any convictions one may hold dear. I said I could not and would not, as this was contrary to our core beliefs, our faith, and our view of the world. Amazon would not listen to any other ideas to talk, brutally telling us to submit or we were done. As a Nebraskan with strong convictions, I refused to bend a knee to Amazon, their ultimatum to adhere to their oppressive mandate, though we did try to come to some sort of agreement with them.
Okay. We got to enforce the light rule.
Ultimately, they shut our business down. They left us with $50,000 worth plus of bills. They took our people and distributed them to their other teams, and that's just how it worked.
Okay. Senator Geis.
Yes, I just want to clarify. You said you had hired someone who was transgender.
We did, and they got promoted.
And did that individual file a complaint?
No.
So how did this accusation come about?
So a disgruntled employee who had decided not to show up to work on time ended up getting fired. This person put in a call to complain that we were discriminating by not using transgender pronouns, even though we did use the individual's preferred name in all of our rosters and all of our radio communications. They contacted me. I informed them that no, that's our strong belief. We were then called from a lawyer in New Jersey from Amazon that informed us that we were in violation of the law, and if we did not change and do that, we were gone. And that's what happened. And they shut our company down, and we were very good at what we did. We delivered over 1 million packages. We led the way in Omaha, and they shut us down based on that.
And did you have representation on your side?
No, and nothing. They apparently conducted an investigation behind my back, calling my staff without communicating to me, and gave us this ultimatum. And that was it. By November, 1 month before the holiday season, where we had previously done before, had experience, had fully staffed, paid off all our fixed costs, they kicked us out and essentially kicked out all of our staff members, and I was able to work with another solid owner to transition them over so their families would not be put in the same place as my family was.
Thank you.
Okay. I do not, Senator DeBoer.
I'm sorry. I can't always hear when people speak to Senator Geis. So did you say it's that a disgruntled employee said that you didn't use the correct pronouns? Is that what the problem was? And Amazon then said because you didn't use correct pronouns.
Well, not that I didn't use. They said in the future I wouldn't do that. They said you will use them in the future, and you will be required to take 1 hour sexual harassment training course, and you will use these or you will be out of our program. And they kicked us out of the program.
Okay. All right. Thanks.
Yeah.
So they said you need to do this and this, or you'll be out, and then you're out. So did you not do what they asked you to do?
No.
At corporate Amazon? No, what?
I did not do what they did and what they mandated me to do, Senator. No, I did not.
Okay. I don't see any other questions. Thank you for being here, Mr.
Thank you.
Welcome. Good afternoon.
Thank you. Mr. Chairman and members of the committee, my name is Matt Sharp, M-A-T-T-S-H-A-R-P, and I serve as senior counsel with Alliance Defending Freedom, the nation's leading legal advocacy organization dedicated to religious liberty. Laws like LB120 that add gender identity and sexual orientation to state employment laws strip away the ability of churches, religious schools, and ministries to make employment decisions based upon the sexual practices or identifications of applicants or employees. The primary mission of many religious organizations is to teach their beliefs to the next generation. This constitutionally protected right is infringed if religious organizations can no longer require their employees, the very people responsible for teaching these doctrines to the next generation, to live consistent with those beliefs and doctrines. And that's precisely the consequence of adding gender identity and sexual orientation to state employment laws. Now, supporters of LB120 have claimed that this bill is required after the Supreme Court's decision in Bostock. This is incorrect. In fact, the Bostock opinion explicitly rejected any effort to extend its decision beyond the context of Title VII, the federal employment non-discrimination law at issue in the case. Quote, "The employers worry that our decision will sweep beyond Title VII to other federal and state laws that prohibit sex discrimination. But none of these other laws are before us. We have not had the benefit of adversarial testing about the meaning of their terms, and we do not prejudge any such question today." The Supreme Court refused to extend its reasoning to state employment laws because it recognized that there are vital differences between state and federal law, particularly as it relates to protections given to religious organizations under federal law. Specifically, the Bostock Court noted that the Federal Religious Freedom Restoration Act provides religious employers with an additional layer of protection against efforts to use Title VII to infringe their freedom. The Bostock Court explained that, quote, "Because RFRA operates as a kind of super statute displacing the normal operations of other federal laws, it might supersede Title VII's commands in appropriate cases," referring to religious employers. In other words, the Supreme Court knew that RFRA would provide a guardrail against abuse of federal employment law being used against religious employers. Nebraska does not have a RFRA. There are no guardrails to prevent LB120 from being misused against religious organizations. And as a result, if LB120 is enacted, churches, religious schools, and ministries will have less protection under Nebraska law than they would and than they're given under federal law. This bill deals a significant blow to the freedom that Jewish, Muslim, Christian, and a variety of other faith-based organizations need to accomplish their religious missions. As such, it should be rejected. Thank you. I'm happy to answer any questions.
Senator McKinney.
Thank you. Thank you for your testimony. Are you saying that it's okay to use religion as a form of discrimination?
Thank you for that question. I think what the Supreme Court said, and is recognized in a variety of cases, is that in order for religious organizations, churches and others, to fulfill their religious mission, they have to have the freedom to be able to hire and employ people that believe those same beliefs and act consistent with those beliefs. So I think the Supreme Court has ruled, and why it was so important to Justice Gorsuch in the Bostock, that we need to make sure that these laws are not used in a way that undermines that freedom, that undermines the ability of religious organizations to accomplish their mission.
Okay. Do you think we should change our state's motto from the good life to "you are not welcome to the good life"?
Not at all. I think everyone deserves to be treated with dignity and respect and to have their constitutional freedoms protected. And as we've seen that our firm is represented, we want to make sure that that also applies to religious organizations, religious schools, ministries, and churches.
All right. Thank you.
Thank you, Senator.
Senator DeBoer.
Thank you for testifying today. Is there, I know I looked at this a couple of years ago, there are some states that have these sorts of laws that have religious institution exceptions. Are you aware of any of these?
I do know that different states have done these differently. There's other states that, like federal law, have state RFRA laws or things like that, and obviously other definitions of religious organizations and exemptions. But as you're well aware, the Nebraska law is modeled very similarly off federal law, yet lacks some of those important federal protections that the Bostock Court pointed to.
If this bill contained in it an exception for religious institutions, does that then take away your objection?
I think it perhaps could address some of them. I think part of the concern is how the interplay between protections for religious organizations and the other non-discrimination laws sort of plays out. But I do think, in addition to that, as some of the other testifiers have brought up, there are other concerns even outside of the religious context that they spoke about. And so I think primarily I was wanting to focus on the religious aspect and the concerns that it raises there, but I do think that is one of the important issues that this bill raises.
But if we can deal with, I think that we have to in some way deal with religious institutions and that sort of thing. And there are a number of, as I recall, and there are cobwebs in between me and remembering all of this when I did the research, but as I recall, there are a number of different ways of handling it, and I think probably there are enough intelligent people in this room that we could write an acceptable religious exemption. Other states have these sorts of things, and they seem to be able to handle the religious institutions within their borders fairly well. So then what objections are left? I don't understand. Well, anyway. All right, thank you.
I see no more questions. Thank you.
Thank you,
We have time for one more opponent. Good afternoon.
Good afternoon, Senator Lathrop and members of the Judiciary Committee. My name is Karen Bowling, Karenbowling, and I serve as the Executive Director at Nebraska Family Council and provide testimony on their behalf. We believe every person should be treated with dignity and respect and not suffer unjust discrimination. Our opposition to LB120 is due to the problematic consequences of making sexual orientation and gender identity a protected class category. In a diverse and pluralistic society, it's not surprising that there are differing views and beliefs pertaining to issues of marriage and human sexuality. These views are held in good faith by sincere and reasonable people, as was noted by the U.S. Supreme Court's majority opinion in Obergefell versus Hodges. Sadly, the government has used laws like LB120 to target small businesses and punish people like Jack Phillips and Blaine Adamson for declining to create custom art that expresses messages that conflict with their beliefs. Just weeks after Jack Phillips, owner of Masterpiece Cake Shop, won a 7-2 victory in the U.S. Supreme Court, which wipes away the Colorado Rights Commission's punishment of Jack under Colorado's statewide sexual orientation and gender identity, the same commission used the same law to launch a new attack on Jack to force him to create a custom cake to celebrate a gender transition. An advocacy group filed a complaint under Lexington, Kentucky's municipal sexual orientation and gender identity against Blaine Adamson, who owns Hands-On Originals, a promotional printing company, for declining to request a particular design. Blaine serves everyone but can't print messages that conflict with his conscience. When the government picks winners and losers, we all lose. Sexual orientation and gender identity require employers to try to discern and honor the many different genders with which their employees might identify. For example, New York City recognizes over 30 different options, including bigendered, agendered, and two-spirit. Other proponents believe gender is fluid and that it varies in people over time. This creates a burden on employees to try to discern and honor the many different genders with which their employees might identify. Employers face costly lawsuits over gender identity. Businesses are currently free to adopt their own policies, of which many already have. And I just want to say something maybe to your question, Senator Lathrop. I do want to give you an example and how would this play out. And it happened actually in a break room here in a company in Lincoln, and a couple were sharing about a weekend to remember, which is a marriage weekend to enhance what we would say a traditional marriage. And there was a complaint from a employee that was offensive to them, and that person was written up simply by only sharing that they'd had a great weekend to remember. So with this comments that I'd like to not advance LB120. Thank you.
Okay. I do not see any questions for you, but thanks for being here today.
Thank you.
That will end our opposition testimony and take us to neutral testimony.
My name is Amber, A-M-B-E-R. Last name is Parker, P-A-R-K-E-R. I just want to say to everybody in this room, I'm so sorry all your voices can't be heard due to rules that, as we, the second house, are silenced by. I'm not an attorney, but I live in the United States of America. And in the United States of America is the governing law of the land, which is the Constitution of the United States of America. But it seems in our state legislatures across this country, now even in our federal government, that there are more and more that want to make our Constitution evolving. A state senator had recently spoke and said something pertaining to the state that about the religious institution, and I was sitting here and I was like, you know what? Right now in State Senator Megan Hunt's bill, she's becoming like a religious institution and enforcing it upon this great state of Nebraska. And Amendment 1 is clear that you can't do that in the Constitution. But because many Americans do not understand the Constitution of the United States of America, and because we have Marxists and communists coming in to destroy the bedrock and the very foundation of what families are built upon, marriage between a husband and a wife, then we have these crafty legislation to come in with the precedent and the goal to rip apart and to enslave us and make America a plantation of slavery, to say if you don't worship our religion of government, you're our slave and we're going to bring persecution upon you. Hearing the testimony of the gentleman that came up in a delivering service, it was kind of hard to hear back there. My heart went out because one of the things that LB120 would do is it's creating a government church by an unspoken power hiding of forcing state religion. There are other countries who have done this, and it didn't end up good. Millions of people died. And right now what we're seeing in the state with Mr. Klein are the Kleins who I believe were bakers, they were fined over $200,000. And it's this type of legislation that brings persecution and then encourages bodily harm against those who are not going to abide by it. But it's recruiting through a state-made religion. So I want to address the bill, not the people and the voices and the feelings and the emotions, because legislation is built upon thinking of what it's going to do at the present time, in the middle, and also in the future. And these are the building blocks that we have to look at. So nobody is being discriminated, but what this does is if somebody's not on time to work, they're tardy a lot, or they're using print materials for something that the company doesn't believe in, that they now could go LB120 and say it was discrimination and bring persecution upon a business, false accusation. So,
Senator McKinney.
Thank you. This is not necessarily a question for you, it's just a comment. Religion was used to enslave my ancestors, and if some of our elected officials had decided not to change that view, I wouldn't be a state senator and I would probably be a slave. So I think the
Not
world,
my religion, just to clarify on record.
the world evolves, and I think we have to change. And to just say no to something because it's against my beliefs, but you're disregarding the negative effects that it has on millions of people is an issue. But thank you.
Well, it's infringing upon constitutional liberties and the governing law of the land, LB 120, and any senator bring type that legislation. It should be concerning for all of us. And I do apologize for those who of your family were slaves. You know, Galatians 5:1 says, "You have been set free for freedom. Therefore, no longer allow yourself to be burdened again by a yoke of slavery." And I want to say to you, I don't see color, I see beauty. And God is way outside the box. This has nothing to do with racism. This has to do with bringing persecution and in a crafty way of creating legislation to uproot the Constitution of the United States of America through sexual orientation and gender identity laws. Furthermore, pedophiles want to be recognized under sexual orientation as well. So,
Okay. I have to say this. There is a place for neutral testimony. You are excused.
Senator Lathrop, you are infringing upon the freedom of speech, and it is across state senators that have said this. So, sir, you cannot bully me. And this is what I'm talking about. All these people deserve to be heard, and you're cutting them off. Thank you.
There is a place for neutral testimony, and it is
You're not going to bully me, Senator. Thank you.
It is not to be an opponent or a proponent. And believe me, we have to observe this because this committee has observed from the time we started hearings this year, many of the rules aren't mine. This is a rule of this committee because of the volume of bills we have and the limited time we have to hear them in. I would appreciate everyone respecting this and not using neutral testimony to come up and express opponent points of view. Those who did not have an opportunity to testify as an opponent on this bill, I would encourage opponents on the next bill to afford them an opportunity to speak instead of having the same people jump up and not allowing those who wanted to speak on this bill an opportunity. Okay? I'm not trying to shut people down or not hear what people have to say, but in order to get through the bills that we have to hear and to do it in a fair and orderly process, I have to enforce the rules that we have, okay? Not trying to shut people down. I'm happy to hear you, and we can talk in the hall if you want to talk, or if you didn't get a chance to visit. You can email senators. We have 4 ways to communicate with us, and we're all happy to communicate with people who have something to say about the issues today. Is there any other neutral testimony? Seeing none, Senator Hunt, you may. Is it neutral testimony? So seriously, I do not want the neutral testimony to be abused today or any day. Yes, ma'am.
So there is no neutral. If there is no neutral people here, then why can't others go ahead and use
It's
that time?
neutral. Normally we don't have neutral testimony. That's when somebody comes in and talks about technical difficulties with the bill typically. They're not for it, they're not against it, they are talking about it, technical difficulties with the bill. Okay? Senator Hunt, you may approach to close. I will, for the record, indicate that we have 82 position letters. 20 of those are proponent, 54 are in opposition. We have the following written testimony offered this morning pursuant to the rules. Proponent testimony from Robert Sanford, Nebraska Coalition to End Sexual and Domestic Violence. Also a proponent, Anna Eichholt with the YWCA. Abby Swatsworth out in Nebraska is a proponent. Meg Megalachek with Planned Parenthood of North Central States is a proponent. Kelsey Waldron, Women's Fund of Omaha, is a proponent. Jenny Benson is a proponent with the NSCA. Kelly Martinez out in Nebraska is a proponent. Craig Beck, Open Sky Policy Institute, is a proponent. And Justin Brady is an opponent representing the Nebraska Realtors Association. Senator Hunt, you may close.
Thank you, Mr. Chairman, and thanks to the committee members. Thank you to all the testifiers who came here to engage today, whether in opposition or as a proponent. I just think it's really great when everybody comes and engages with their government. And I know that this committee gets more than a lot of other committees of that engagement, so I appreciate all of you. This bill does not infringe on anybody's free speech. It doesn't infringe on anybody's religious liberty. The court got it right in Bostock. Religious liberty can coexist with fairness and non-discrimination, and religious liberty has never given a broad license to discriminate, whether that's on the basis of national origin or race or ability or gender or sexual orientation or gender identity. This bill also doesn't prevent people from being fired for being bad at their jobs. If it just says that if you are fired for being LGBTQ, if you're fired because you've got a photo of your husband or your wife on your desk and it's a same-sex spouse, that you can take that employer to court. And the court will go through its process, and you'll be able to try and prove your case, just as you would in any other type of discrimination case. I would encourage you to reach out again to Ms. Marna Munn from the EEOC if you have any questions about how that would play out on the government side. It's certainly different from what it would be in a private corporation or something, when we're talking about how government would actually handle a problem like that. I appreciated so much Mr. Ralph Kellogg coming to testify and talk about his experience in discrimination. And when he said that LGBTQ people understand how to play the pronoun game, that completely spoke to me. I've completely been in that position where you have to say they instead of she in my case, or you have to say, my friend and I, when you mean my girlfriend. And that's a really painful thing, because the reason you're censoring yourself and you're speaking that way and basically lying and misrepresenting who you are is because you don't know what the other person's gonna do. You don't know if the other person's gonna say, use a gay slur at you, which has happened to me. You don't know if they're gonna exclude you from events in the future, or talk behind your back, or worse, or fire you, or worse, or commit violence against you. I mean, we have reason to fear these things. I also, Senator Geis, my friend, you asked about, does Nebraska feel unwelcoming? And do you feel unwelcome in Nebraska? And it is unwelcoming and it's hurtful when you use language like choices you have made to refer to sexual identity or to refer to being LGBTQ. That's a choice that you've made. It's okay if you think that, if anybody thinks that, but it's an unwelcoming thing to say to somebody. And even in my own workplace here, I find it unwelcoming when I read in the newspaper that it was reported that a colleague of mine said that I'm, quote, trans, and I talk about it most every day. And then when I asked that colleague about it, they said, I don't even know what you are. And I find it unwelcoming when we vote on legislation on the floor, like Senator Cavanaugh's bill from 2019 to change our marriage certificates from bride and groom to spouse and spouse. The least controversial thing we could do, even straight people have a spouse. This isn't even a gay thing we're trying to do. And that bill gets filibustered, we pass it, it gets vetoed, and we don't override the veto. And I have to listen to colleagues stand up and talk about, oh, well, they're going to be marrying their chair, they're going to be marrying their toaster. If we don't specify that it's a bride and groom, who knows what their genitals are going to be doing in the bedroom. Like, just listen to how prurient it is for people to talk about LGBTQ rights in Nebraska. And me, being an LGBTQ colleague of you people, listening to them talk about it like I'm not even in the room, that is unwelcoming. I've had colleagues here ask me if I've ever even been with a woman and what it was like. Does that feel welcoming? Do straight people get asked stuff like that? I have a colleague here who found out I was dating a man, and he said, thank God, because I thought you were a little bit weird about that stuff. What the hell does that mean? And I'm a state senator. That is my experience as a state legislator in the capital of our state. And so, for people to say this isn't a big deal or it doesn't happen, I mean, I'm obviously fine. I get through it, life goes on, I do fine. But I have experiences that other people do not have to deal with, and then because they don't deal with it, they get to say, well, I don't know that it happens, or I don't really think it's a big deal, or, well, it's my religious liberty. And so, but when does other people's dignity supersede your right to discriminate? And what religion are you that tells you that you are actually being the good guy by saying you should be able to lose your job because you've got a same-sex spouse? I hope that if your religion is right and you end up at the pearly gates and St. Peter or whatever asks you, did you do your best on earth? And you say, yes, I did. I obeyed the teachings of Jesus, whatever. That doesn't come back to you, because that is not Christian, and that is not Jesus-like, and that is not compassionate. And I'm not even a religious person, and I shouldn't have to tell people that just so that I can mind my business and do my job and live my life and be here on behalf of other people in Nebraska who want to do the same thing. I am really excited that we have the support of Mayor Stothert in the city of Omaha for this bill. I'm grateful to Mr. John Carl Denkovich, who's here in the room, and he submitted a letter conveying the support of the mayor. We have the support of Mayor Leary and Baird here in Lincoln. We have the support of the State Chamber of Commerce, which was a long time coming. And I will certainly work this bill. And there are so many stories of discrimination and people wanting to leave the state and people not seeing this as a place where they can build a future because we do not have this law. Because we do not have this law. It costs $0.00 for any of you, for any testifier to come up here and say, well, I believe that nobody should ever experience discrimination. You don't even know me. You don't know my life. And if you knew me, you knew that I wasn't racist. You would know that I'm not homophobic. You would know that I'm not misogynistic. I have a wife. I have a daughter. I have black friends. I have gay friends. It costs nothing to say that. It's the least risky thing you can do is come up here and say that. What I want us to do is push the little green button on the floor of the legislature and pass legislation so that we can actually change policy and do something about outcomes for these people and not just come up here and say, well, that's not what I feel in my heart. Prove it. Push your green button. Thank you.
Senator DeBoer.
Senator Hunt, I apparently don't know everything that's in this bill, so I'm wondering, we heard a lot today about using specific pronouns. Can you speak to how that's addressed in your bill, and if your bill would require employers to use specific pronouns without facing, can you speak to that issue, please?
Re-education? No, nothing in my bill would require or mandate uses of specific pronouns.
Okay.
No.
All right, thanks. I think that's it.
Thank you.
That will close our hearing on LB 120 and bring us to LB 230. Also a bill of Senator Hansen. I think we have some people moving around, so we'll let them move in and out of the hearing room before you begin.